Okay, let's dive into this. Welcome to the Explainer. Today, we are setting up a really high-yield, visually structured review of contract damages. Now, if you're a law student currently staring down the barrel of your final essays and those tricky multiple-choice questions, or honestly, even if you're just someone fascinated by the sheer mechanics of how the law fixes broken promises, you are absolutely in the right place. We're going to conquer the core concepts together, clear up some of the more confusing exceptions, and give you exactly what you need to totally understand the block-letter law.
Think of this agenda as your ultimate attack outline. It's a rule-to-application blueprint designed to help you build a perfect IRAC on your exams. We are going to fly through 1. Expectation damages and their limitations, 2. The duty to mitigate, 3. The lost volume seller, 4. Liquidated damages versus penalties, and finally 5. Punitive and nominal damages.
So let's start right at the foundation with Section 1, Expectation Damages and Limitations.
Right off the bat, when a contract is breached, the court's default instinct isn't actually to punish the bad guy. Instead, the baseline rule is expectation damages. If you look right at the definition we have here, it's money designed to put the injured party in as good a position as if the contract had been performed. That is the golden rule, the absolute default standard for contract remedies. The entire goal here is compensation for lost value, not punishment. The law is looking forward, essentially trying to simulate a world where the breaching party actually just kept their promise.
But, how do we actually measure that lost value? Well, we generally split damages into two distinct buckets. First, we have general damages. These are the direct, immediate harms from the breach, basically the difference between what was promised and what was actually received. But then we have special or consequential damages, which are the indirect harms. Now, in the business world, consequential damages almost always mean one thing: lost profits. And because those claims can grow to be truly massive, courts have to put some pretty strict guardrails in place.
And here are those exact guardrails. To recover damages, especially those huge consequential ones, you have to overcome 3 big limitations. You really want to memorize these because they are literal magic words for picking up essay points. First, the damages must be foreseeable at the time the contract was made. Second, they must be proven with reasonable certainty, meaning you can't just guess or pull a number out of thin air about how much profit you might have made. And finally, the harm must not have been preventable by the injured party.
Which brings us nicely to Section 2, the duty to mitigate. That idea of preventability, it basically means an injured party has an affirmative duty to minimize their own waste, which we call mitigation. To brilliantly illustrate this, especially in employment contracts, we have to look at the incredibly famous case of Parker versus 20th Century Fox. So, the studio breached a contract to pay actor Shirley MacLaine $750,000 to star in a musical called Bloomer Girl. To mitigate the damage, the studio turned around and offered her the lead in a dramatic western called Big Country, Big Man, for the exact same amount of money. She said no thanks and sued for her original salary. The studio fought back, arguing she failed to mitigate her damages by turning down that second movie.
So, the crucial point here is how the court defined the rule. Employees must seek out and accept substantially similar work to mitigate their damages. However, they are completely within their rights to reject different and inferior options. Ultimately, the court ruled that MacLaine was still owed her full $750,000 salary because, as a matter of law, a dramatic western is different and inferior to a song and dance musical. She didn't have to take a job that altered her entire artistic trajectory just to save the studio some money.
Let's move on to Section 3, the lost volume seller. Now, what's really interesting about this slide is that we are going to shift the paradigm entirely away from the standard mitigation rules because this is a highly tested exception that trips up countless students. So what if the injured seller has unlimited inventory? Say a buyer breaches a contract to buy a laptop, and the store immediately sells that exact same laptop to someone else for the exact same price. Did the store mitigate its damages down to zero? Well, standard logic says yes, but the law says actually not necessarily. And this is the core concept of the lost volume transaction. You really have to follow the logic here. Unlike employees like Shirley MacLaine, who only have 24 hours in a day and literally can only shoot one movie at a time, a large retailer or a contractor with excess capacity has a virtually unlimited supply of goods or time. If the first buyer breaches, that second sale isn't a substitute that fixes the harm. Not at all. It's actually an additional transaction the seller would have made anyway. Because of the breach, the seller missed out on a second profit.
If we consult the textbook explanation here, we uncover exactly how standard commercial code rules kind of fall short on this. Standard UCC rules on cover say, hey, just resell the goods and sue for the difference. But if the seller has a readily available, massive source of similar goods, reselling the items simply doesn't make them whole. At the end of the day, they are still short one entire transaction.
The absolute landmark application of this is Neary versus Retail Marine Corp. Here, a buyer contracted to buy a boat, put down a deposit, and then completely breached because of an emergency surgery. Now, the dealer sold that exact same boat 4 months later for the exact same price to a totally different person. The original buyer wanted their whole deposit back, claiming the dealer suffered zero damages. But the court said no way. The dealer is a lost volume seller. They are legally entitled to the $2,579 lost profit from that initial breach contract, plus some incidental storage costs, simply because they had the capacity to sell 2 boats, not just one.
All right, Section 4. Liquidated damages versus penalties.
Let's dive into the really high-stakes math of stipulated damages. I'm telling you, this is an absolute favorite topic for tricky multiple-choice questions. Liquidated damages are written right into the contract. It's the parties agreeing ahead of time exactly what the damages will be if things go south. When this is a reasonable, proportional estimate of anticipated harm, courts will strictly enforce it. But if it's an unreasonably large sum used basically as a threat to coerce performance, the court will strike it down as an illegal penalty. Remember, the law wants to compensate. It does not want to allow private parties to economically terrorize each other.
To put that into perspective, just look at this staggering number. In the case of Lake River versus Carborundum, Carborundum guaranteed Lake River a minimum amount of powder to bag and distribute. If they fell short, a contract formula dictated they pay for the unshipped quantity. Well, demand plummeted, and this formula demanded Carborundum pay $241,000. Judge Richard Posner looked at this formula and noted it was designed to always assure the plaintiff more than their actual damages, regardless of how severe the breach actually was. It was a penalty, plain and simple.
Let's move to and see how this builds into the absolute IRAC rule you need for assessing whether a clause is a valid liquidated damage or a void penalty. It's a straightforward 2-part test. First, at the time of contracting, the actual injury from a potential breach must be genuinely difficult to estimate accurately. Second, the stipulated sum must be a reasonable estimate of the probable loss. If damages are super easy to calculate or the number is just wildly inflated, it gets thrown out.
And this brings us to another fascinating penalty case, Aflac versus Williams. Here, an attorney's retainer contract stated that if the client, Aflac, ended the contract, they owed him 50% of the sums due for the remaining years of the agreement. The court struck this down completely. Why? Because the client has an absolute legal right to fire their attorney at any time. Forcing them to pay a massive 50% penalty violates public policy and the attorney's fiduciary duty of undivided loyalty. Economic coercion literally cannot be used to trap a client.
Finally, we reach Section 5, punitive and nominal damages.
To conclude our structured black-letter law review, we have to look at the outlier damages that fall totally outside standard expectations. Read this incredibly powerful quote from Chief Judge Breitel in Garrity v. Stewart. "The freedom of contract does not embrace the freedom to punish." This brilliantly illustrates why punitive damages are generally completely unavailable in simple contract breaches, even if the breach is super intentional or malicious. The power to punish is a monopoly held solely by the state. Unless the breaching party's conduct rises to the level of an independent intentional tort, like fraud, you simply cannot get punitive damages in a contract dispute.
On the exact opposite end of the spectrum, we have nominal damages. These are just token awards. They happen when you can absolutely prove a contract was breached, but you cannot establish any actual monetary loss with reasonable certainty. A famous example of this is Friend versus Washington Square Press. A publisher breached a contract to publish a book, but because the author's lost royalties couldn't be calculated with adequate certainty, the court awarded him exactly 6 cents. It was a legally victorious, yet practically a very hollow win.
Which leaves us with this final, completely provocative thought. If contract damages are purely about making the economic math work without any punishment involved, what about the theory of efficient breach? Economic theorists argue that if a seller can break a contract, pay the injured buyer their full expectation damages, and still make a larger net profit by selling to a third party who values the goods more, well, society as a whole is better off. It's an efficient breach. The seller wins, the new buyer wins, and the original buyer is fully compensated. But does this purely mathematical approach undermine the fundamental moral weight of keeping a promise? It's a really deep question that bridges the rules you just memorized with the underlying philosophy of the law itself. Think on that as you prep for your exams. Good luck, and thanks for joining us for this explainer.